A very new topic which we are going to speak about, and I am Sanjay Chaturvedi, is how private is your privacy. We have been talking about lot of social media, lot of platforms and lot of other things, but the privacy a person is having in India, how private it is, how private is your data. What you do in private is what anybody's affair. Now you must have seen there are so many social media websites or mobile apps and other softwares or microblogging websites like Twitter or Facebook or LinkedIn, Instagram, and on your mobile, WhatsApp, there may be various applications and app you download and use, and before you start them, there is a license agreement, and the agreement wants your permission to indulge or go into your contract, your photographs, your private data, all other, they will ask you to open a Bluetooth, they will ask you to open, give access to mics, sound, speakers, contact, photographs, videos, everything what you store in your mobile. So unless you give them the permission, nobody is going to indulge into the privacy of your data and yourself. Now, let us go a little bit legal. What the legal Standi? What is my local legal Standi? Or whether my privacy is protected under the Indian Constitution and Indian law? Whether I am having a fundamental right as a privacy. Yes, the Indian Constitution has given you as an Indian citizen the right to privacy under Article 21. There was a historical judgment. I'm going to cite before we go deep into the privacy and the data, and then today's what is happening between Twitter and government, between WhatsApp and government, and what they are wants to take the permissions, and what government wants to indulge into, at what stage they want to go in for that. We are going to speak all about it, but before that, let me give you one fundamental historical judgment which came into in Supreme Court, and I'll give you the citation. Actually, it came in 2012, decided in 2017, that in a writ petition, civil writ petition 494 of 2012, Justice K.S. Puttaswamy retired was the petitioner with another people and versus the Union of India. Now this judgment has been divided, and it was delivered by the Mr. Justice Dr. Chandrachud. This judgment has been divided into various sections, and why I am giving you little section-wise details of this judgment is very important aspects of our day-to-day life, and we must understand what exactly is the privacy. What is my privacy and why I should be protecting it, or what is my right under the Indian Constitution to protect my right of the privacy. So this particular historical judgment was delivered, and it has some sections. What the judgment has said. The judgment says that we have actually, there were some references, and then the decision was again revisited of very, very old matter. It was somewhere in 1954 or 1956, one historical judgment on the privacy of MP Sharma case, very famous case, MP Sharma, and there was a decision in 1962 by the Supreme Court of India in the matter of Kharak Singh. Now, these two matters have actually had been referenced throughout in the judgment of this historical judgment. And what was these two matters? I will give you some very brief, very quick reference on what had happened in these two matters. Then the Gopalan doctrine were also discussed by the Honorable Supreme Court, where the fundamental right is isolated silos, or maybe the doctrine per se was actually discussed. Then there was the discussion of Cooper and Maneka Gandhi's case. Then there was some discussion on the origin of privacy, definition of privacy, what exactly is the privacy. Then the natural and inalienable rights of an individual person under the Constitution of India, vis-a-vis Article 19, all the six fundamental rights given under the Article 19, and read with Article 21, which is the right to privacy, which is being given by the Indian Constitution to you. Then evaluation of the privacy doctrine in India, how the doctrine has been evolved over the years. After this 1962 quote, this is almost, you can say, 60, 70 years previous to that, and much water has been passed after that. Still, we are into that particular fundamental, you can say, expression which the Honorable Court has actually revised. And what are those Indian Constitution's provisions, Article 25, 26, we are going to discuss today everything in very nutshell. I am not going to take much of your time, but you must understand that how private is your private data, how private is your privacy. So under those lines of this particular judgment, we will take a tour on what the Honorable Supreme Court has actually was thinking, and a historical judgment was actually delivered. Then we will come into the current issues of WhatsApp and Twitter and Facebook and all that, and the current guidelines which the central government has come up with. Now, the comparative law on privacy was also discussed by this particular judgment, where the UK decisions, US Supreme Court's decisions, constitutional right to privacy in South Africa, constitutional right to privacy in Canada, and privacy under the European Convention of Human Rights and the European Charter was also discussed. Decision of the Inter-American Court of Human Rights were also discussed. Now, 9 judges of this court, the Honorable Court, assembled to determine whether the privacy is a constitutionally protected value. The issue reaches out to the foundation of a constitutional culture based on the protection of the human right, and enables the court to revisit the basic principles on which our constitution has been founded or established, and their consequences for a way of life it seeks to protect. This case presents challenges for constitutional interpretations in the front of this Honorable Court, and if privacy is to be construed as a protected constitutional value or right, it will redefine in a significant ways our concepts or liberty and the entitlements that flows out of these protections. Now, see, the question before the Honorable Court was whether what is the definition of privacy, how different it is, and what are those components in the privacy, and whether the Constitution and Article 21 very specifically, whether it protects. and what are those fundamental rights under the right to protect or right to have a privacy or right to have a private life, life to liberty is being given in Article 21. The basic question, whether privacy is a right protected under our constitution, requires an understanding of what privacy means. For it is when we understand what interest or entitlements privacy safeguards that we can determine whether the constitution protects privacy, whether the constitution protects the privacy in India. Now, the court has been addressed on various aspects of the privacy, including which says that whether there is a constitutionally protected right to privacy. If there is a constitutionally protected right, whether this has the charter of an independent fundamental right or whether it arises from the within the existing guarantees of protected rights such as life and personal liberty. The doctrine foundation of the claim to privacy and the content of privacy and the nature of the regulatory power of the state. Now, whether the state, how much, at what level it can indulge into the privacy of an individual is the question before this honorable court. Now, what the courts was actually gone for it. When the 8 judges of this court, let me give you those two case histories very briefly, which is of MP Sharma and Kharak Singh. Now, in MP Sharma case, it was in 1954. What was the matter? It was actually a company went into a liquidation, and it was alleged that the company manipulated its books of accounts, and the case was registered against the company and its director that whether the company has had some criminal offenses made into this. Now, you can say in 1954, it is almost 70 years almost, the court established that speaking for a majority of all the benches and all the judges and all that, constitute that the relationship between the Article 19 and 21 to be one of the mutually exclusion. In this line of the equity, what was comprehended by the Article 19 was that Article 19 excluded from the Article 21. The 7 freedoms of the Article 19 were not subsumed in the fabric of life or personal liberty in Article 21. What was the Kharak Singh case? The Kharak Singh was actually a derided dacoit, and in some of the local state act of UP government, that it gave the right to police to indulge and go and check and vouch the house and raid whether the accused is at home at night. So they used to just knock and just whether see that whether Kharak Singh is sleeping in the home or no. So Kharak Singh went into the court and said, "Sir, this is my personal life and right to sleep, and this is my human right as well. It is not just fundamental right. It is my human right whether I should get a sleep. Even animals get it. So why should I not get that fundamental right under that?" So the court have given a verdict in Kharak Singh case also that yes, the right to liberty or right to life or right to privacy in the night, whether the person is there or no, was the Kharak Singh case. Now, this is two cases basically, and the court has come up with a fundamental explanation into these two. Based on these two explanation, the current matter was also very much influenced by these two matters. Now, the right to privacy is implicit in the right to life and the liberty granted or guaranteed to the citizens of this country by Article 21. Now, it is a right to be let alone. You just leave me alone. That is what actually the expression of the article is. You leave alone, and a citizen has a right to safeguard the privacy of his own. Mind you, a citizen has a right to safeguard the privacy of his own, his family, marriages, proclamations, motherhood, child being, or education, among the other matters. None can publish anything concerning the above matter, a press or a media or somebody else. Now you know that how the microblogging websites, people just go on publishing somebody else private affairs, just put on the photographs and this and that. But a person has the right to have privacy, where you cannot put my photograph on your Facebook wall unless I give you a permission. Maybe I may be a icon, or maybe I'm a good actor, or I'm in a public domain, but right is protected as far as the family, marriages, education, motherhood, and my private life with my partner, in my bedroom, in my vacations. What I do and what I wear is nobody's concern. So whether truthful or otherwise, and whether laudatory or critically, whatever it is, you cannot publish my private movements on public domain. Whether you are a press or whether you are a person who is connected with me or not, unless I give you a permission. If he does so, suppose whosoever does it, he would be violating the right to privacy of the person concerned and would be liable in an action for damages, for sure. The position may, however, be different if a person voluntarily give you a permission and gives you a chance to publish or make it happen. The rule aforesaid is subject to the exception that any publication or any concerning the aforesaid aspects becomes unobjectionable if such publication is based upon public records, including court recordings, and in a fabric of society where a democratic republic is being damaged. That means in the public interest or for the protection of the sovereignty of the nation, any information which is being published, or maybe in a society where a damage to the culture and heritage of the nation or democratic republic values, then that time such information which may not be a private one, but you may have your own opinion. See, right to expression is Article 19. But I am talking about right to have a privacy, that is Article 21. I am not talking about right to speak or freedom of speech right now. I am talking about whether somebody got right to indulge into my privacy or no, first. And it can, in the Karaksing case, which says that if suppose somebody is actually having some actions against the nation or maybe the sovereignty of nation, then some such privacy is not of an individual person. Then it will be in the nature of the sedition into the nation. Now coming back into the various microblogging websites like Twitter, Facebook, and all other platforms. What are they? They are basically a software giving you a platform to express your opinion, your information, your sharing the information with your friends, family, and like that way. Now, what is the tussle between these microblogging websites and the government? Does it have any impact on your privacy? No. Why? Because what is the issue? The issue is that the government is asking that we must know that whatever the information or some as information which is having the damaging the sovereignty of the nation, you must tell what is the origination of it. Now I'll give you an example of Twitter. What was the issue of the Twitter was that there was some BJP leader who actually had published some photograph which was actually tagged as manipulated media. Whether Twitter is judgmental? Yes, because you are just a microblogging website. You should be neutral. Whether somebody is putting something and they are putting something, you should be judgmental. You cannot be a judgmental. If the police asking you that what information you have as far as that particular media is concerned, that you have tagged it is a manipulated media, the Twitter should have actually come up with saying that okay, we got this information that this is a manipulated media, and then you would have given to the society. Instead, the microblogging website have actually made a statement saying that it is the attack on the freedom of speech. You are not citizen of India. Citizen of India knows from 1952 onwards that how to protect a privacy or how to have a liberty to have a freedom of speech under Article 19. And we have various methods and various media to express the freedom of speech. Now 2, 3, 4 things have mixed up. I am talking about whether I am having a privacy or no. If and only if you give some permission to somebody to indulge into your privacy. Now I'll just give you some example. You surf on net, maybe any search engine, or maybe on YouTube, or maybe on some certain, even if microblogging websites, maybe Facebook or something, which you just click and you surf or search some item, maybe a towel or maybe some FMCG product or whatever. How come in next couple of days or till week, everywhere you go, such type of items, advertisements or something will pop up, and all that. That means somebody is looking at what you are browsing. And because of that, they are having some artificial intelligence. They cannot see, there are millions of people using that software. So they are looking at what exactly you are browsing and using that particular data to have an effective advertisement campaigns for their advertisers. So this is what exactly happening. But you cannot blame that, because to use those microblogging websites, you have also have accepted that yes, you can see that what I am going to see. Using the government issues and what Twitter and WhatsApp and this and that in some other matter or some other episode I will cover. It's a separate different IT act actually altogether, which got nothing to do with the privacy of our generation. I hope you must have enjoyed this. You can always write to me in the chat box below, or you can write one email to me at editor@saptakala.com. I'll be much obliged and much happy to assist you anywhere if I can.